Hello everyone, I'm attorney and professor Kirk J, and I want to welcome you to this, the second in our series of mini lectures dealing with topics in employment law. Tonight we're going to be talking about unemployment compensation. However, before we begin our mini lecture today, I want to remind you that the information provided in this mini lecture is for educational purposes only. It's not meant to be legal advice. If you're facing a serious issue at work, you should contact an attorney who is licensed in your jurisdiction. Before we discuss how unemployment compensation works, kind of specifically, let's talk generally where unemployment or the compensation of unemployment came from. The idea of unemployment compensation came as a result of the Great Depression. And in the Great Depression, many workers lost their jobs through no faults of their own. As a result of losing their job, they couldn't pay their bills. They were unable to provide for their families. So over time, the states and federal government worked together to develop a system of compensation for employees who have lost their job due to no fault of their own. The best way to think about unemployment compensation is to think of it as insurance. It's encouraged on the states by the federal government, but the states themselves actually administer the unemployment laws. And the ways the states do that is they collect money from employers through payroll taxes that employers pay on a quarterly or perhaps a monthly basis, and they put that money into a giant trust fund. And when someone is entitled to unemployment benefits, the state pays that person out of the trust fund that's been set up to pay unemployment benefits. Remember that unemployment is designed to offer compensation to folks who have lost their job through no fault of their own. So the focus is, did the employee lose their job due to no fault of their own? And in general, you can think there are two ways for an employee to lose their job. One is they could quit, or two, they could be fired. In general, states have two different rules. One is if the employee quits, the other is if the employee is fired. Let's take the quit first. The general rule in North Carolina, which is where our lecture is and is probably followed in most states, is that if an employee quits, they are not entitled to unemployment compensation. Why is that? Because if you've quit your job, you're unemployed through your own fault. In other words, no fault of your own generally does not apply. So the general rule is if you quit your job, you're not entitled to unemployment benefits. Now there are a few limited exceptions. For example, if you quit your job due to your health, if you quit your job because due to no fault of your own, your employer has substantially reduced your pay or substantially reduced the number of hours. However, again, the general rule is going to be the employee who quits is not entitled to unemployment compensation. Now, let's take a situation where an employee is terminated. The general rule for a termination is if you're fired, you're going to get your unemployment benefits unless the employer offers evidence that you have engaged in misconduct or in substantial fault. Now, what is misconduct? Misconduct is conduct for which a reasonable employee should know that they would be terminated. And I like to think of those in kind of two concepts. One would be what I think of as legal misconduct, and the other is rule-based misconduct. What is legal misconduct? Legal misconduct would be those types of things that anyone would know, if I do this in the workplace, I am going to be fired. And for that, I'm thinking about very specific actions that harm the employer, like stealing from your employer, going up to your supervisor and punching him in the nose. Those types of things any reasonable person knows is going to get you terminated, and that's going to be misconduct such that you would be denied unemployment benefits. The other type of misconduct is rule-based misconduct. Rule-based misconduct would occur when an employer has a specific rule, the employee is aware of the rule, and violation of the rule would lead to termination. If the employee knows the rule exists, The employee knows that if they violate the rule, they will be terminated, and yet they violate the rule anyway. That is what is considered rule-based misconduct. I'll give you a crazy example. Let's say that I have a rule in my office that no one that works for me can wear the logo of a institution that was a competitor to my alma mater. And one day I come in and my legal assistant has on a logo on a hat of a competitor to my alma mater. I've told her, or she's read the rules, that she can be fired in that circumstance, and I do in fact fire her. That would be misconduct. Why? Because she knew about the rule and she violated the rule anyway despite her knowledge. In that circumstance, the employer would provide evidence of the rule, and the government would quite likely say that is in fact misconduct, again being that type of rule-based misconduct. I think it's important for you to remember that in North Carolina and in most states, if you file for unemployment benefits and you are denied your benefits by the state initially, you do have the right to appeal that decision so that you can show that you are in fact entitled to your benefits. And the state will schedule you a hearing that is an evidentiary hearing, a little bit like a trial, in which you can present your own evidence and can attack the employer's evidence or show other evidence that rebuts the employer's evidence and show, in fact, you are entitled to unemployment benefits. In any case, though, the basic rules are the same, which is generally if you quit, no unemployment benefits, but generally if you're terminated, unless there's misconduct or fault, you're going to get your benefits. Thank you. I'm attorney Professor Kirk Angel.